morning, Your Honors. David Friedman on behalf of TK, the father in this within paternity matter. This is a co-parenting arrangement in a paternity action where the child support guidelines do not apply as a result of the shared parenting plan and also mother's substantial income alone. As a result, the court calculated support on the premise that each home will have an equal amount of income for the benefit of the child. And I would say that's
before you get there, if
Sure.
I could just ask you, are you pursuing the argument that none of this applies because this was a paternity action and not something else? I mean,
I'm
are you
saying-
drawing a distinction between 209C and
I'm
divorce or something?
Excuse me. I'm saying that when applying an equalization of income theory, without findings as to the needs of the child or a disparity in the standards of living, that it's such an imprecise calculation that anything in excess of the needs of the child would be, in effect, support for mother. And we cannot have, in a paternity context, support for mother, which would amount to spousal support or alimony in the context of a paternity.
So you would make, if this were a marriage, you could make the argument that you couldn't call it support for the child because it really is support. I mean, it would be the same argument, right?
Right. The idea behind equalization of income theory is that we establish, well, it's typically done it's almost always done in a divorce or post-divorce matter where the non-custodial parent earns substantially more than the custodial parent.
It's the Castle-Hubbell.
It's Castle-Hubbell, exactly. And the idea is to maintain the pre-divorce standard of living. So how can, in a paternity matter...
But are you really drawing that distinction? I guess what I'm trying to get at is if 209C is supposed to be treating children born not of a marriage equally with children born of a marriage, it seems to me that however valid your argument may be with respect to Castle-Hubbell, I'm trying to figure out what you base the idea that children of a marriage should be treated differently than children outside of a marriage.
And I guess the way to answer that would be the fact that this is very different than all those other equalization cases because it is a true co-parenting arrangement. So as a result, by almost imprecisely saying that we're going to make sure these parties have the same income, you're taking away from a house where the child spends 50% of her time. And that is a huge distinction between all the other cases that have talked about equalization of income.
Could I go back to Justice Botzer's question maybe and ask you if you're, what I thought you were saying is that this does differ from a marriage which is also governed by 2834, among other things, because of the intersection and interplay between support and property and lifestyle, which is a major component, not the only component, of 2834 distribution. So that I thought you were arguing, but clarify for me, that in a marriage, depending on how long it is also significant that there was a certain lifestyle that the parties had together that you then can't reduce. And then you equalize as much as possible through support and distribution. And because you make the argument, I thought, that by looking to assets, you're actually also doing something like a distribution, which is not warranted in these. Is that incorrect, or is that?
No, that's wonderfully stated, actually. I wish I would have said it as well. And we're looking at the standard of living that existed when a family was intact. But in a paternity matter, the family is never intact. It is two people who have a child out of wedlock, and what this case stands for is that a parent who has a child born out of wedlock with another parent is entitled to the same equal amount of income as the other parents, regardless of the needs of the child or a finding as to a disparity in the parties' standards of living.
But I guess that was a very helpful question. I agree. But if, for example, you did have a much greater disparity between the standards of living between the father and the mother here, are you saying nonetheless you couldn't do this?
Absolutely. I'm saying there's the first hurdle that it's inappropriate in a case like this. But second of all, if you were to do an equalization of income theory, there's not the proper, it's deficient in its findings to even do that step.
The mother, though, is by herself, according to paragraph 12, paying for all uninsured medical and dental expenses, all extracurricular activities, and the child is what about is.
She's turned 7 on December 24th.
I know her age now, not
this
that.
includes ballet and soccer and all the other things that 7-year-olds in her position will be doing. It includes private school, it includes daycare, it includes medical insurance, all to be paid by her. It seems that he did pretty well paying $23,608 and not having to pay for those. Isn't that basically, I mean, one can argue that she's being asked to pay these things by herself, and it's probably going to come to more than $24,000 a year, and he's being asked to pay a little bit less than $24,000 a year to her. It seems like that's pretty equal.
But I guess my problem with this is we don't know. And what customarily took place is that before the paternity action happened, is the parties lived separately, and each of them paid 50% of her expenses. And that's the only equitable way to do it, rather than to...
So you'd be happier, you may regret this if
I may.
you get it, but you'd be happier if it said they'll share all uninsured medical and dental expenses, all extracurricular activity, all daycare, all private school.
That would be the only way that would be equitable.
Even though it may mean that your client may be paying more.
It may be, but there's no reason why mother in this case should be the one who gets to determine what these expenses are, pay these expenses. This is as true of a co-parenting arrangement as you can find. And in fact, father is the parent who's home with the child during the day. Now she's at a school age, but at this time he was the stay-at-home parent, while mother works full-time as a successful physician.
And therefore would need daycare to maintain her employment when the child's with her.
Correct, or utilize father's more flexible schedule. And that was the basis of the case. And so I guess to come to that second step, if we are doing an equalization of income, there is no finding that there's needs for the child. In fact, the court's findings directly conflict with this, saying that she has comparable homes with shoes, clothing, toys, strollers, furnitures, and toiletries. Further, father has already funded 50% of the child's college education. I don't see that the child has any needs outside of the arrangement that they had prior to this judgment. What the parties had done is they agreed to split daycare expenses and agreed to split the medical and dental expenses, and that's how they were moving forward with this. The second prong to that would be the standard of living. And the court the appeals court looks to father's greater assets to say it's implicit in the court's findings that father has a greater standard of living because he has greater assets. And I see no relationship, or I see the true measure of standard of living is expenses and not income, not assets. We can look and see that mother's expenses on her financial statement are $140,000 a year, which includes $200 per week for clothing, $175 per week for travel. She lives in a newly renovated house.
Yes, but your client didn't list his expenses or didn't accurately list them.
My client accurately listed his expenses, and the court found that he wasn't living a lifestyle commensurate to his income.
But I thought there's a finding about he didn't list vacation. There was a variety of expenses that were not on his financial statement.
Sure, and several of those were. I recall that it was there was a $25,000 repair that he had to make on a boat. There were a $6,000 gift to his daughter. They were one-time expenses, the kinds not typically found on.
Wasn't one of them adding to the college fund?
Adding to the college fund was a one-time expense. It's not something that's on a weekly basis. He fully funded 50% of her college.
How can you know what the college?
It's through a U plan it's essentially an annuity where he puts in 50% of it, and it entitles the child to go to any school within the Commonwealth. So that was the way he took care of it to secure her future. And instead, the court attributes income to father and says that because he lives a lifestyle not commensurate to his listed income. This directly conflicts with the court's findings.
I thought she looked at his bank statements and things. I mean, it wasn't just sort of he lives a different way than what his expenses are.
Well, the judge found that he lives a lifestyle not commensurate to his not commensurate to his income, and then looked to try to figure out how she was going to attribute income to him. And she did that by looking at his withdrawals from one checking account. She noted that over the course of the case, he withdrew a certain amount of money, but his assets, his liquid assets, as she stated, did not depreciate.
Well, he said he was paying for things out of his savings account, but his savings account went up, I don't know, $24,000 or something.
His total assets went up throughout the case. And what the judge doesn't look at is that over 90% of those assets are securities accounts. And securities accounts totally fluctuate with the market. And it's not true money or cash in hand until that money is withdrawn or realized. So the court does give consideration when father's assets go down $70,000 and say, perhaps we don't know why they went down, perhaps it's a fluctuation in the market, but doesn't give that same consideration to father when the accounts go up. The court does find, however, that father is retired. They find that he's living off of assets, and he's dissipating the assets because they order him to maintain a $500,000 mortgage on his house, saying that we don't know what's going to be left by the time he dies. This is direct. There's no and then they say, father, we're imputing an income net of taxes of $147,000 to father based solely on his withdrawals. This is in direct conflict. There is no finding that he's earning less than he's capable of, that he has some sort of a job that's out there, that they find that he is retired, and there is no finding that the retirement is voluntary or that he has an earning capacity greater than he presently has.
Can I ask you a question?
Please.
If all of this happened and it was in a divorce setting, would it all have been okay?
The equalization?
Well, what was done here? If you change the facts and it's not a child born out of wedlock, but a child born during a marriage, would this order have been all right?
No, Your Honor, it would not, because there is no finding still as to the needs of the child or a disparity in the standard of living. Essentially, it is looking at an attributed income that was falsely attributed and then equalizing income while that has no rational relationship to the needs of the child. It's, in fact, in essence, it deprives the home where the child spends 50% of the time. What gets lost in this is that co-parenting arrangement, that this isn't the non-custodial parent situation that we most commonly see. These are people equally with this child. And without rationale and without proper findings, the court comes out and says that we're going to equalize these people's income, and father is going to be the one paying, as opposed to mother, who is a successful physician making $150,000 a year. They have father pay mother, and that's inequitable.
But I assume that if she were making $40,000 a year, your view would be different. So it's because of the magnitude of her income that you say it's appropriate to be equal.
I believe I would. Of course, I would still ask for the proper findings to be there, but that would be more the Castle and the Hovell situation. But in essence, we have a castle and a castle in this case. And I'm sorry.
No, answer. Finish your answer.
That's all I had, castle and a castle.
Going back to something you were talking about, that she didn't find that he could be working and he wasn't, et cetera, et cetera. All true. But if she finds, and she makes a credibility finding, that your client was not credible in terms of his finances, what is she to do?
Well, I would first start in understanding the difficulty in overturning a credibility issue. She finds that he lacked credibility for not listing values to certain things on his financial statement: a boat, a house, and his parents' estate. he lists these assets on every single one of his financial statements and lists value uncertain. Again, not a divorce case. This is a paternity case, and where assets were not to be divided. He did not know the value of a boat that's extremely hard to appraise, a house he had listed the assessed value on his financial statement, and a parent's estate that had not been probated. There is no way that he could have put these values down without certain expense to him, which seemed unnecessary in a paternity action, and something that mother's counsel, through due diligence, could have done herself. They also find his income to be not credible when he attaches his 1099s to his trial financial statement. What better income, what better evidence is there to show what father's
He
income
gave
is?
his tax returns, right?
Pardon?
He didn't want to give his tax returns.
No, that's not the case, Your Honor. He was not ordered to, this was a separate
Well, he
appellate
could have
issue.
volunteered them.
He provided his 1099s. The tax returns weren't prepared, and that's why he could not provide them to her. But he gave her all the supporting documentation, and the appellate court held that that the court could not compel him to do that.
Mr. Friedman, we'll have to leave it there. Thank you, sir.
Thank you for your time, and thank you for the opportunity.
Good morning, Chief Justice, Your Honors. If it please the court, my name is Brian Kelly. I represent Mother, in this case, the appellee. I would initially start out by saying that it is Mother's position that both the trial judge and the appeals court got it right, that this is a situation in which completely is within the trial judge's discretion to award this type of child support. There are no guidelines in this case, as my brother has pointed out, obviously because of the amount of income.
So was there any finding that in order to mandate, in order to sort of maintain, I should say, the child's lifestyle, that there needed to be an equalization of income? Was that a finding?
It was found, Your Honor, by the trial court, not in those words.
Okay.
But it was found in establishing that Mother has equity of $46,000. That's her house, her IRA, her car, everything. And Father has all of these other assets. And the court...
But the lifestyle maintenance issue, I mean, the child was living in both places in very good lifestyle, and was there some change that required this equalization?
Well, Your Honor, I would say to you that this court, in the case of Department of Revenue versus Mason M., and that's in my brief, has established this whole issue of how do you find the needs of a child. And in fact, what this court has said was that the children's needs are defined at least in part by their parents' standard of living. Okay. And the question is, well, what's the standard of living? Now, Father, on one hand, seems to be arguing, well, you didn't really make an issue of define what the standard of living is, and I really don't know what, beyond what Judge Kaplan did, she could have done. Father, by his own doing, chose to withhold numerous assets right in his financial statements. He doesn't list $1.6 million condominium, a 55-foot yacht, which at trial he does admit he valued at $340,000. He doesn't put a figure on the interest in his parents' estate, yet at trial he admits that there was a bond for the executrix in that case of $300,000. He also, this is one actually that the trial judge put in her finding but then kind of missed at the end, is that there was a claim, his wrongful termination claim for Oppenheimer was around $1.6 million, and the judge says that he didn't put that in, and yet she doesn't kind of calculate it that at the end. There is...
But what is that? I mean, those are assets, and we're not talking about a divorce, and so we're talking about standard of... I mean, how does that translate into what the standard of living for the child is?
Well, again, I would call this court's attention to General Law 209C, Section 9C, and they list about 4 or 5 factors, and there are 2 really that are the key ones, and first is 1 and 2. 1 is the needs of the child, and 2, we keep talking about the standard of living, but actually factor number 2 says the relative financial means of each parent, including standard of living, age, health, amount of income, amount of unearned income. So the factor is not just what's the standard of living, but it's what is the financial means of each parent. And in this case, what the court and the appeals court found was that this is not a situation where there's a windfall for mother. We're talking, as I believe Justice Gantz had said, we're talking about $23,000. I think you actually had the right number. I just rounded it to $23,000.
$23,608.
Which, in the grand scope of things, as the appeals court said, is not a windfall
But we're talking
for mother.
about the principle and really how this translates into other circumstances and trying to grapple with if standard of living is going to be so significant in cases of people who aren't married but have children they are raising equally. What does that mean? Are you, and if you push that, are you suggesting, for example, that you should in these cases value, say, the father's dwelling? And if it's a $2 million dwelling and hers is worth $400,000, it's perfectly okay if she goes buy, and she should be able to buy one, and that if the father has savings, he should be required to dig into those so that he can make the support payments that would translate into a mortgage payment that would permit her to have an equal type of dwelling.
Yeah, exactly.
Does it go that far?
I'm not going to go. I wouldn't go that far, Your Honor, because if it is, as it pertains to the facts of this case, they're not looking to equalize the homes. And clearly, he has a $1.6 million home.
I know.
She has a.
But you're
all that they're
focused
looking
on
for.
lifestyle. You care
sorry.
a lot about boat value and something that is really only relevant, as far as I can tell, but perhaps by your extrapolation of relevance to children in this circumstance, parents' estates that haven't been probated,
Right.
future wealth. Okay. So all of those things, all of the 20834 factors that look to assets, including future assets like this, are relevant, should be considered where parties are not married, raise children equally, because they should have the same lifestyle.
And again, I would call the court's attention back to the Mason case. But what I would say to you, Your Honor,
Trying to put some
is
meat
that
on those bones.
I see
and asking
exactly
for
where
your
you're going,
help.
Your Honor. But what I'm saying is that recall this is not a situation where they're saying mother should have a $1.6 million house too. What the court is taking, and Pearson and all the other cases, Cooper, I believe, is the best case that kind of summarizes all of these Pearson-Brooks cases. But what they all tend to say is that the judge has discretion to look at all of the circumstances. Here, Judge Kaplan looks at all of the circumstances, and she doesn't say, well, you've got assets of over almost $4 million, and mother has assets for $46,000. Okay, what she says is, that's what I'm thinking globally. I'm seeing where we're standing. But all she's basically doing is saying, I'm going to just take the income. And if you look at what she uses for the income, again, at father's doing, because he doesn't provide all of this stuff, is the judge has no recourse but to say, I got to do something. I mean, and in all the cases, the Clark case, the Kane case, and all those cases, they say if one party is not cooperating, the judge certainly can do what he or she has to do to establish what the money is here. Judge Kaplan has one choice. I've got to find somewhere to figure out what this income is. And she likes to look at statements from 2005, 2006, not 2007. They don't get that far. But she finds $147,000 of spending in 1 year. Next year, she finds $193,000. The next year, she alludes to the fact that it's higher, but nobody actually gives an exact figure as far as that's concerned. And mother's contention would be, she gave him a good break. I mean, she could have, if you take a look at all of the savings, as I believe Justice Botsford had said, or perhaps I'm sorry, but the savings account went up $24,000. He invested $100,000 in an offshore investment. His spending in 2006 was $131,000, and it wasn't just the one-term gift or the repairs to the condo. It was $70,000 worth of credit cards that he paid off every month. All
But
of
it
these
did
things,
include those other things, including
right? But
attorney's
it
fees
wasn't,
and all of those.
you know, and Judge Kaplan, in thinking, I'm looking at all this, these figures, I've got to somehow figure how to be equitable, and she has that right under Pearson, because there's no guidelines here that she can do what's in the best interest of the child. And it's not giving...
So from your perspective, it doesn't matter whether it's 209C or divorce. Is that right?
Oh, yes, that's correct.
So what's the guiding principle here? And what was guiding this judge's analysis? And what were the interests of the child that the judge sought to address?
One of the things that is significant in the judge's rationale is also that mother, according to all the calculations that the judge made, mother has a $30,000 shortfall. Now, you can obviously say, well, mother shouldn't spend that much. Okay, that's fine. But father's also spending money on yachts and things, and again, that's fine. But the judge's findings in the rationale found that, and I believe it's, if you actually look at the further appellate review document, which is letter C, the mother found, that's the judge's rulings, that on page 2 of that, the judge found that mothers had a weekly shortfall of $766, which translated to $39,000 a year. Recall, Your Honors, that this was after they separated. You know, we keep calling this a paternity action, and it is. But this isn't the same situation as the Department of Revenue versus GWA case, when it was obviously an extramarital affair. The father in that case had a family and had children, and that parties never lived together. These people, they didn't have the marriage certificate, granted, so it's not a divorce. But these people lived together since 2002. They lived together for 18 months with this child. Okay, and then they finally couldn't work it out, so they split. Yeah, did they go through the probate court, and did they have a marriage and then have a divorce? Absolutely not, so it is technically a paternity suit. But what I'm saying is that while the judge has this discretion, she did not abuse this discretion, and there was no clear error in what she did. And this child, for all intent and purposes, but for a marriage certificate, there was an intact family. And I would call the court's attention just to the preamble of the guidelines. And the preamble of the guidelines, as cited by this court in Mason, says it's to provide a standard of living the child would have enjoyed had the family been intact. I mean, you can argue semantics whether this was an intact family because they didn't have a marriage certificate, but for the first 18 months of this child's life, this was an intact family. And I would assert to this court that this judge did not do, the trial judge did not do anything to abuse the discretion or was plainly wrong, and the appeals court is right in the fact that she did everything she could, balancing all of the circumstances so that child wasn't lacking in any way.
Now, Mr. Friedman tells us just a moment ago that in view of the amount of income earned by each parent, that what would be the only appropriate course was to say it goes 50-50, which would mean that all the expenses in paragraph 12 that's borne by your client would also be those equally shared. Do you agree that that's a fair resolution?
Well, again, I would, I'm sorry, yes, I didn't mean to be flippant. Yes, I mean, that's the other side of this thing. The concentration of father seems to be, boy, poor me, I'm paying all this money, and yet all of the medicals, insurance, the uninsured medicals, the daycare, the schooling, everything else falls on mother. And the position that father had taken in its brief was, just because it's a paternity suit, father shouldn't be essentially, and he did not use this word, but it's the only one coming to me, he shouldn't be saddled with all the expenses of a child just because it's a paternity action, and yet mother is, and again, I don't mean any disrespect, saddled is a bad word, for lack of, you understand what I'm saying.
But
Mother's got
Right, I
all
understand,
this, as you
but
said,
are you telling us that what we should do is that we should reverse this judge's decision and say, no, you must make it 50-50 with no exclusions?
I can't say that, Your Honor.
You
I
can't
cannot-
because...
I cannot say that because I don't know what I had argued initially was that it should have gone back to the non-amended complaint in which mother would have paid the insurance, father would have paid the $454 a week, and that all the uninsured over and above the $250 would have been split 50-50.
Well, what about the
That was
college?
argued.
What about the college fund?
College?
Do we undo that?
The college fund, I actually believe, Your Honor, and it is addressed in the rationale, in either the rationale by the trial judge or in her order, was I believe that there's credit given. The father is not to, I don't believe he's, and again, I can't say this for certain because I don't have the figures. I don't believe it was
But if we were to go 50-50, if the rule were to be 50-50, all expenses shared equally, we undo the college fund?
I believe
Or make some kind of an arithmetical
because
adjustment?
mother has also contributed to the college fund also. So I can't say that, I'm sorry.
But it wasn't half. It wasn't
No,
even close.
absolutely
It was
not,
just a couple
absolutely not. It was
$1,000.
$2,000.
Yes.
But the funds shall be utilized to pay for college, and each party shall receive a credit in the amount of their contributions to their share of the college expenses. That's what the rationale has to say. I see that my time is up, and I would rest on the brief. Thank you, Your Honors.